Welcome back to another deep dive.
Mm.
Ever wonder where your property rights end and your neighbors begin?
Oh, it's a question for the ages, isn't it?
It really is. And today, we're stepping into a world where wind chimes can be a sonic assault,
Oh, tell me about it.
and a house full of pups sparks a legal battle. That's right, it's nuisance law.
And it's a lot more relevant to your everyday life than you might think, really.
Yeah.
These cases, they reveal this fascinating tension between individual freedom and the responsibilities that come with, well, living next to other people.
It's kind of like a legal balancing act.
Exactly.
Right. We've got excerpts from a legal textbook to kind of guide us through the weeds.
Oh, absolutely.
But the real eye-openers are the actual court cases. Get ready for some neighborly showdowns that are stranger than fiction.
Oh, absolutely. These places aren't just about, legal principles, They're about real people with real problems trying to find solutions.
Yeah.
Let's dive into our first case, shall we?
Let's do it.
Our first case takes us to, a seemingly idyllic rural neighborhood that found itself at the center of a, shall we say, barking mad legal battle.
I love it already.
It all started when two families, the Dobbs and the Richards, who had enjoyed this tranquil slice of the countryside for decades, suddenly found themselves under siege by barking dogs.
Okay, I've got to ask, how many dogs are we talking about here? A couple of noisy pups or something more substantial?
Well, substantial is putting it mildly. We're talking 69 dogs.
69 dogs.
Yes, you heard that right. 69.
69 dogs. That's not just a dog park. That's practically a whole dog census tract. I can only imagine the cacophony.
It was definitely beyond your average barking incident, let's just say. Imagine trying to enjoy your morning coffee while dozens of dogs howl in unison.
Oh my goodness.
The Dobbs and Richards families claimed they couldn't even hold a conversation in their own backyards or even sleep with their windows open.
So they did what any reasonable person driven to the brink by barking would do. They took the case to court.
That's right.
This is Dobbs v. Wiggins, right? What did the court have to say about this symphony of woofs?
Well, this is where it gets interesting. The court had to determine whether the barking constituted a substantial interference with the neighbor's right to enjoy their property.
Hold on. Substantial interference. Sounds like lawyer speak to me. Break it down for us. What does that actually mean?
It's a key concept in nuisance law. Basically, it means the harm caused has to be more than just annoying or inconvenient. It has to be significant enough that a reasonable person would find it unreasonable.
So it wasn't enough to just say it was annoying. They had to prove it was significantly impacting their ability to live a normal life on their property.
Exactly. In this case, the neighbors brought in witnesses, other people living nearby, who could attest to this symphony of woofs. Even someone 2 miles away said they could hear the dogs. They presented evidence of how often and how loud the barking was, really painting a picture for the court.
2 miles. Okay, yeah, that's excessive.
Yeah.
But here's the thing. The dog owner wasn't some heartless Cruella de Vil, right? He bred and trained bird dogs. It was his livelihood.
That's right. And that's the tricky part. The dog owner argued that he was in a rural area where this kind of activity was, expected. He was using his property for a legitimate business.
It's that classic, I moved to the country to get away from the noise argument, except in this case, the noise kind of followed them.
Precisely. This is a classic example of how courts have to weigh competing interests. The dog owner had a right to use his property, but not if it unreasonably interfered with his neighbor's enjoyment of theirs. And in this case, with 69 dogs, well, it was a hard argument to make.
Okay, so what did the court decide? Were the neighbors forced to invest in industrial-strength earplugs or soundproof their homes?
The court actually sided with the neighbors. They agreed that the barking was a nuisance, B-U-T. Instead of just shutting down the dog breeding operation completely, they sent the case back to the lower court to figure out a more, balanced solution. They wanted the court to determine the magic number of dogs that would be acceptable enough for the owner to maintain his livelihood, but not so many that the neighbors were subjected to constant barking.
So no easy answers in nuisance law, just a whole lot of barking mad situations and a whole lot of legal wrangling to try to find a compromise.
What this case really highlights is that nuisance law is incredibly fact-specific. It's not just about what the activity is, but how intense it is, where it's happening, the impact it's having, and even the character of the neighborhood. What's considered a nuisance in one setting might be perfectly acceptable in another.
That makes sense. Okay, well, before we move on to our next case, which involves a very different kind of nuisance, no animals involved this time, What's the key takeaway you think our listeners should remember from the case of the 69 dogs?
I think the biggest takeaway is that while you have the freedom to use your property as you see fit, that freedom comes with the responsibility to consider how your actions might impact those around you. It's a balancing act that requires understanding and respect for the rights of others.
Perfectly put. Now, get ready to take a trip back in time, folks, to the 1980s, when computers were massive, the internet was dial-up. The curious case of technology gone wrong set a legal precedent.
Ah, yes. This next case takes us back to a simpler time, before Wi-Fi and smartphones, to a time when the cutting edge of technology could be found in a travel agency. Intrigued? Let's rewind to the 80s and delve into the case of the computer that ruined TV time.
This is the case of Page County Appliance Center.
Okay.
And it really shows how nuisance law has to adapt to, well, changing times.
Yeah.
Picture this. A small-town appliance store in Iowa starts experiencing some seriously strange technical difficulties.
Okay.
They're televisions, and not just one or two, but rows of them.
Wow.
All throughout the store.
Okay.
Started acting up
Really?
the culprit.
What?
Electromagnetic radiation.
What?
Coming from a brand new computer system installed in a nearby travel agency.
Hold on, you're telling me a computer from the 80s with all its bulky glory was emitting enough radiation to mess with TVs next door? I mean, I know those old computers were power hogs in terms of electricity, but radiation? It sounds almost far-fetched now, right?
Yeah.
But this was, cutting-edge technology back then.
Yeah.
And it was emitting enough electromagnetic radiation to interfere with the appliance store's TVs.
Wow.
The court actually noted that television sets were commonplace in most households at the time, so the appliance store wasn't doing anything unusual or overly sensitive with their property.
That's a good point. It wouldn't be a nuisance if it was only bothering something super rare or out of the ordinary.
Right.
Like, I could see how a rock concert next door to a meditation studio might be a problem, but not if it was a library.
Right. You've hit on a key concept in nuisance law, unusually sensitive use.
Okay.
You can't claim nuisance just because your particular activity is disrupted, especially if it's something most people wouldn't be bothered by.
Right.
In this case, watching TV was a totally normal use of property.
For sure.
The court actually ruled that the computer interference was unreasonable.
Okay, so score one for the appliance store, right? The travel agency had to get rid of their fancy new computer.
Well, not exactly. It's not quite that simple.
Okay.
And this is where the case gets even more interesting.
Okay.
The appliance store didn't just sue the travel agency that owned the computer.
Okay.
They also went after the companies that made and maintained it, ITT and Honeywell.
Whoa, really? So they could go after the tech giants behind this radiation-emitting beast. Why bring them into it?
This case wasn't just about who was using the computer, but who was responsible for the nuisance it was causing.
Okay.
ITT owned the computer, but Honeywell designed it, built it, and provided ongoing service. The court really had to grapple with the question of whether these companies were materially participating in the nuisance. Basically, did their actions contribute to this mess?
So it's like, if your neighbor throws a party, you might not sue the guests for being noisy, but you might have a case against the homeowner who didn't do anything to quiet things down.
That's a great analogy.
Thanks.
And in this case, ITT tried to argue that they were just the landlord, so to speak.
Okay.
They leased out the computer. They weren't responsible for how the travel agency used it.
Okay.
Honeywell, on the other hand, said, hey, we built it, but once it's installed, it's up to the user, not our problem.
But what about shoddy design? What if they knew the computer emitted a lot of radiation and didn't do anything about it? Surely they bear some responsibility for that, right?
Exactly.
Yeah.
And that was the million-dollar question for the court.
Yeah.
Ultimately, the court found that both ITT and Honeywell could be held partially liable.
Wow.
They said that because ITT received financial benefit from leasing the computer and had even been made aware of the interference it was causing,
Right.
they had some responsibility to address it.
Makes sense.
And Honeywell, because of their ongoing service contract and the possibility that the computer's design contributed to the problem, couldn't just wash their hands of the situation.
Talk about a cautionary tale for tech companies. You break it, you buy it.
Right.
Or in this case, you design it to disrupt, you pay for it.
Right.
It really makes you wonder, what will be the computer interference case of our time?
That's an interesting question. We live in a world increasingly reliant on wireless signals. Imagine a homeowner whose smart home system goes haywire because of interference from a neighbor's new gadget. The possibilities are endless.
Okay, so for all our listeners out there living in smart homes and surrounded by wireless devices,
Yeah.
you might want to brush up on your nuisance law.
Now, speaking of things that can cast a wide net of influence,
Okay.
sometimes literally,
Yes.
our next case brings us to the sun-drenched shores of Miami Beach for a legal battle that's all about sunshine, shadows, and the high-stakes world of luxury real estate.
Okay, I'm intrigued. Let's head to Miami for some legal drama, sunshine, and maybe a virtual mojito while we're at it. Welcome back to the deep dive. We're basking in the Miami sun, virtually speaking, of course, to unpack a case that's all about, well, the lack of sun, actually.
That's right. Our next case, Fontainebleau Hotel v. 4525 Inc., takes us into the glamorous and sometimes shady world of Miami Beach hotels. We've got two luxury hotels side by side, both vying for guests and prime oceanfront real estate. The Fontainebleau decides to build a fancy new addition, a towering structure that promises to be, well, the epitome of luxury.
Sounds great. Who doesn't love a luxurious hotel upgrade? More sunshine, more ocean views, more tiny bottles of shampoo. What's the problem?
Well, the problem was the shadow. You see, this brand new addition, as impressive as it was, cast a massive shadow over the neighboring Eden Rock Hotel's pool and sunbathing areas.
Oh, I see where this is going. Talk about throwing shade, literally. So the Eden Rock, understandably, wasn't too happy about trading their sunshine for a permanent eclipse.
Not at all. They argued that this new shadow would be, well, detrimental to their business, claiming it would deter guests from choosing their hotel and wouldn't exactly scream prime sunbathing spot in the brochures. Imagine paying top dollar for a luxurious Miami Beach experience only to find yourself lounging in the shade. Not quite the idyllic getaway one imagines.
Okay, yeah, I can see their point. Ocean view with a side of perpetual shade doesn't quite have the same ring to it. So, did the court side with the Eden Rock? Did they tell the Fontainebleau to shorten their new building, maybe add some strategically placed mirrors to redirect the sunlight?
This is where it gets interesting. In a move that surprised many, the court actually sided with the Fontainebleau.
Oh, wow.
They basically said, look, having a building next door that casts a shadow on your property, even if it's your pool, isn't a legal nuisance. Essentially, there's no legally protected right to uninterrupted sunlight.
Wait, so even if it impacted their business, the Eden Rock had no legal recourse? That seems a little harsh. I'm starting to feel a little shady just thinking about it.
It does seem a bit cut and dry, doesn't it? But this case really highlights how the law weighs economic arguments against, well, traditional property rights. The Fontainebleau argued that their addition would not only boost their own profits, but also create jobs, attract more tourists, and ultimately be a huge win for the local economy.
So they weren't just thinking about themselves, they were thinking about the greater good.
Exactly. And to bolster their argument, they even cited the Coase Theorem, which, in simple terms, suggests that when it comes to resolving these kinds of disputes, the most economically efficient outcome should prevail. In this case, the court agreed that the Fontainebleau's addition, with all its economic benefits, was the more efficient outcome, even if it meant a little less sunshine for the Eden Rock.
I've heard of the Coase Theorem, but honestly, I've always been a bit fuzzy on what it actually means in practice. How would that apply here? Are you saying the two hotels should just work it out themselves?
Exactly. The Coase Theorem, in its purest form, suggests that if the parties can bargain freely and without high transaction costs, they'll reach the most efficient outcome, regardless of how the law is structured. So, in theory, the Fontainebleau could have offered some form of compensation to the Eden Rock for the loss of sunlight, maybe a financial settlement, or even something like, agreeing to promote each other's businesses. It's about finding a mutually beneficial solution, even if the law doesn't mandate it.
Okay, that makes sense, but I imagine those kinds of negotiations can get pretty complicated, especially when you're dealing with big businesses and even bigger egos. It's not always easy to find that win-win scenario.
You're absolutely right. The Coase Theorem is a beautiful concept in theory, but real-world negotiations are rarely that simple or straightforward. And the Fontainebleau case really sparked a debate about fairness. Should economic gains always trump an individual's right to enjoy their property, even something as essential as sunlight? It's a question that continues to be debated in legal circles today.
That's a really interesting point. It makes you think about the trade-offs we make in the name of progress, and who ultimately bears the cost of those trade-offs. All right, well, we've gone from barking dogs to interfering computers to shady real estate dealings. It seems like nuisance law pops up in the most unexpected places.
It really does, and it just goes to show that even in the 21st century, the basic principles of neighborliness and, respecting other people's right to enjoy their own property are just as relevant as ever.
It's a good reminder that we're all in this together, even when it comes to noise, shadows, or, well, 69 dogs. Thanks for joining us for another deep dive into the fascinating world of law. Until next time.